Morning, Deputy Registrar.
Good morning, Madam.
Good morning.
I believe we've got the call out, so I'll wait for the clerk to call out. Okay, thank you.
The hearing on this matter is being held by way of teleconference. The directions hearing today is in the matter of CFI 021-2020 before Deputy Registrar Nour Hineidi. The claimant is represented by Evershed Sutherland. Lead counsel is David Craig QC, assisted by Amy Roger. The defendant is represented by KBH Kanoon. Lead counsel is Bushra Ahmed.
Thank you very much. Mr. Craig, over to you, please. Thank you.
Well, Madam, we're grateful to the court for listing this hearing at short notice. As you would have seen, the principal matter in issue is as to when the trial should be listed, and in particular whether, assuming the court can accommodate us, it should be the 31st of May or sometime in August or early September. Madam, have you received a note from us in relation to that?
I have. Thank you very much, Mr. Craig, and I've read it already. Thank you.
I'm grateful, Madam, and in the light of that, I'm obviously not going to take you through all of the matters in that note, but can I just highlight a few? And Madam, do you also have a bundle, whether electronically or in hard copy?
I do have a bundle. Is that the one that's 320 pages long?
Yes, including the authorities, that's right, yeah.
Fantastic. Yes, thank you very much.
Madam, could I ask you just first of all to pick up page 182?
Thank you, and I've got the letter in front of me.
Thank you. You'll see that's a letter from us as long ago as the 26th of February, in which we suggested to the defendants that they consented to the grant of injunctive relief, and we proposed directions to a 3-day trial to commence on the 10th of May. And Madam, you'll see that on page 184. At paragraph C, the second paragraph on that page, you'll see that we invited the defendants to agree directions for a speedy trial. And at paragraph 8, we set out some directions with a trial to start, you'll see at letter I on the 10th of May, and those directions included for us to serve our particulars of claim by the 2nd of March and the defendants to serve their defences by the 16th of March. I should say that we did indeed serve our particulars of claim on the 2nd of March. And eventually on the 17th of March, the defendants agreed to that start date. And Madam, you see that at page 196.
Thank you.
At paragraph 2.1, that was subject to certain conditions, but in due course, there was some correspondence about that. But in due course, that was effectively agreed in principle, and as a result, Madam, on page 217, we wrote to the court. Sorry, Madam, tell me when you've got there. I'm sorry.
Sorry, yeah, I'm just loading it. It's just loaded. Thank you.
You're about halfway down that page. We wrote to the court on the 29th of March, setting out that the parties had at least agreed in principle for a trial to start on the 10th of May, albeit that at that stage we were yet to agree formal directions. And Madam, you'll see on page 216 that the court wrote back to us the following day, the 30th of March, setting out that the case wasn't going to be listed at that stage and asking for the parties to agree a list of issues for an update on the employment claim before the English court. And Madam, you may know that that's a reference to the fact that the second defendant, Mr. Olayanju, had told the court at the...
Sorry, Mr. Craig, I think your voice is cut out. Hello? Mr. Craig? Just to check to see who's on the line. Ms. Ahmed, are you still on the line?
I am indeed, yes.
And Evershed is still on the line?
Madam, sorry, I had obviously some problems with internet connectivity.
No problem, Mr. Craig.
But
I was looking at page 216, where the court directed... Yes, go ahead, thank you.
Yes, I'm so sorry. Directed various matters, and I was just saying Mr. Olayanju had told the court at the interim relief hearing that he was going to bring a claim in the English Employment Tribunal, and the court wanted an update. And so at page 223, in the light of that, we wrote to KBH with a list of issues and asking for an update on the Employment Tribunal claim.
Yes.
And Madam, at the top of page 224...
Yes, thank you.
The last paragraph of that letter, there's reference to the defendant's request to push the trial date back from what had previously been agreed, the 10th of May, to early June to give the defendants time to prepare their evidence. Madam, if you want to look at it, the letter from the defendant is at page 164, and their request to push the trial date back to June is at page 166, paragraph 4.3. But Madam, you can see from our response to that we were flexible and accommodating to the defendants and agreed to push back the trial to the 31st of May, effectively, so the beginning of June, but the 31st of May was the Sunday. That was our letter of the 2nd of April. Madam, at page 225, 4 days later, on the 6th of April,
yes.
Having received no response, we chased again. And then, Madam, at page 228, we received a letter from KBH on the 8th of April, so a week or 8 days or so after the defendants had asked to push the trial back to the first week of June. And in that letter, the defendant suggested that because of the impact of COVID-19, we simply put the timetable on hold and revisit the matter in 2 weeks' time. And Madam, you see that at page 229 in the penultimate paragraph.
Thank you.
Madam, at page 232, please.
Thank you. Thanks, Mr. Craig. Mr. Craig? I think we're having issues with the connection. Can everyone confirm, please, starting with Evershed, have you dialed in using the Skype link or have you dialed in using the telephone function?
Skype link.
Skype link, okay. It's perhaps best that the telephone function is used because the Skype link sometimes is not very reliable. So if Mr. Craig is not logged in through the telephone link, it might be best perhaps, at least for counsel, to dial in through the telephone link, and then solicitors are, free to also dial in through Skype if that's what they wish. Usually through the telephone link, we just find it's a little bit more reliable. Ms. Ahmed, are you dialed in through Skype or through telephone?
On Skype.
No,
I
through
can
telephone. Telephone, okay. Sorry,
Shall
and
I
is Ms. Rogers on the phone?
I'm on the telephone, madam.
Thank you.
Do we need to get to David to tell him to try the telephone?
Thank you, I've done that.
Oh, thanks, Amy. I'll do the same.
Thank you. And Mesa, while you're on the line, I know all the parties are listening in, but while you're on the line, it might be worth mentioning to council when they dial in that the best dial-in method is via telephone and not through the Skype link, so that they are legible. Thank you.
Madam, it's David Craig. I have in fact been using the phone link, but I'm assuming we're now waiting for other people to join in some different.
Oh, you have been using the phone link. Oh, okay.
Yes.
I'm back in on the phone link.
Fantastic. Well, let's proceed. If there's any further issues, I'll get the IT team to look into it. We haven't had issues with hearings before, so I don't know why the line keeps cutting in and out. But let's see how we go. Do we have everyone else on the line? Ms. Ahmed's on the line, Ms. Rogers is on the line, and Evershed, I believe, also on the line.
Yes, yes, we joined. Yeah, and Mr. Singh as well. Speaker, are you still there?
Yes, I'm there. Yeah, thank you.
Thank you, Mr. Singh. Good. Mr.
Thank
Craig,
you,
we're up to page 232. I'll let you continue. Thank you.
Madam, yes, and you may not have heard, but I asked whether you could just reread that letter to yourself, if that's convenient, rather than me read it out to you.
Of course. On page 232, correct?
Yes, please. 232 to 233. It's just over a page that I...
Thank you. Just give me a minute, please.
Of course.
Thank you, Mr. Craig.
So, Madam, just a few things to pick up in that letter. Firstly, we said that we would be flexible about trial dates, and if the defendant's preference was to push the trial date back to the autumn, then we would consider that, and we asked them for their proposals in that regard. Madam, you'd have seen the reference to the list of issues, and you'll recall that the court had asked the parties on the 30th of March to agree a list of issues, and we had sent our proposed draft list of issues to the defendants on the 2nd of April, but 10 days later had heard nothing, and I think it's right to say we've still heard nothing in relation to that. And we had chased about the status of Mr. Olayanju's employment tribunal proceedings, which the court had also asked for an update on in its email of the 30th of March. And, Madam, there's also reference there to the Part 19 request that we served on the 7th of April, which KBH said that the defendants would endeavour to respond to by the 29th of April, so yesterday, whereas we had been seeking a rather quicker response. I should say we haven't received, so far as I'm aware, the response to the RFI that we served. Madam, we received no...
Mr. Craig? Okay. Mesa, I think it would be best to get IT onto the phone, please. help identify the problem. Is Mr. Craig still on? No. Matha, are you there, please?
Yes, I'm here now.
Fantastic. Could you please contact the IT team? We'll just adjourn the call
Madam,
for 5
I'm sorry.
minutes. Are you there, Mr. Craig?
Yeah, I'm sorry. It's obviously a problem with my connectivity. I am dialing on a telephone.
That's really odd. I wonder if I'm just trying to think of practical solutions, because I think it would be, you must be feeling quite distracted by all the disconnection that's happening. We can either adjourn very briefly and try and get the IT team to look into the issue, or we can continue and hope that there's no further disconnections to the line. I'll leave it in your hands.
Well, can we try and press on? I think if as long as that's convenient to you, if that drops up again, what I might do is try from a different line. I might try from a mobile phone. Maybe that would be better. This is a phone that connects. Yeah. So I am sorry. I appreciate it's me who's calling.
No problem at all. No problem at all.
So, Madam, I was saying we received no response to that letter. So we wrote again on the 17th of April. Madam, you see that letter at page 244. Could I ask you just quickly to read that letter too, please?
Yes, please give me a few seconds. Thank you.
Yes, of course.
Thank you, Mr. Craig.
And so, Madam, that is what prompted our letter to the court on the 17th of April, which is at page 235.
Bear with me, Mr. Craig. I'm going to that page now. Got it, thank you.
And Madam, you'll see that we were asking the court to list the short telephone CMC as soon as practicable. And Madam, I've taken you to that correspondence in part because it's clear that we have been the ones who have been trying to push matters along. And you'll recall it's at page 252 of the bundles that on the 19th of April, KBH suggested on behalf of the defendants that the court should not list a CMC until after the 7th of May. That's at paragraph 1 of their email.
Yes, thank you.
So again, taking a rather more relaxed approach to this litigation, and Madam, of course, you know the court indicated that the parties were to agree directions by the 23rd of April, or the court would list a CMC. And so, Madam, at page 250, about halfway down the page, in the light of that, we immediately asked the defendants what their proposals were. And you'll see at the top of page 50, we didn't have a response to that. And so we chased again 2 days later, on the 21st of April. And then, Madam, at page 264, please, at 9:30 in the evening on the 21st of April, we received from KBH draft directions to a trial in August. That was the first time there had been any suggestion of a trial in August. And just to be clear, it's the defendants who were now suggesting that the trial did not commence on the 31st of May, as we had previously agreed. And Madam, we wrote back promptly at page 263 on the 23rd of April to make clear that we could agree the directions, save us a trial date, because of witness and counsel availability, but we could accommodate a trial in September. And Madam, we repeated that at page 276, in which we made clear that there was no period in August when all of the claimant's witnesses were available. So, but again, made clear that we could start a trial in September. So again, we were flexible, but the defendants, frankly, haven't been. And the upshot of that is really as follows.
Sorry,
first, we are the ones. Yes.
I had disconnected very briefly for a minute or so. I do apologise. I'm not sure what the issue quite is. My last discussion, or rather the last point that you were putting forward, was on page 252, and that's what I got up to.
Oh. Yes, sorry, madam, I'll take you back. So at page 252, madam, that was paragraph 1 of the email from KBH on behalf of the defendants. It was the defendants who were suggesting that the court shouldn't list the CMC until after the 7th of May.
Yes.
So again, it was the defendants who were taking a rather more relaxed approach to this litigation. And as you know, the court indicated that the parties were to agree directions by the 23rd of April, or the court would list the CMC. And madam, at page 250.
Yes, thank you.
We immediately asked the defendants what their proposals were, because clearly the ball was in their court. And again, we had no response to that. And you can see at the top of page 250, we chased the defendants on the 21st of April for their position.
Yes.
And then on page 264, please, you'll see that just after 9:30 in the evening on the 21st of April, the defendants sent draft directions to a trial in August. And madam, that was the first time that there had been any suggestion of a trial in August. And to be clear, it's the defendants who were suggesting that the trial didn't commence on the 31st of May, as had previously been agreed. And madam, we wrote back promptly, if you go please to page 263.
Thank you.
Making clear we could agree the directions, save us a trial date because of witness and counsel availability, but we could accommodate a trial in September. Which we repeated at page 276, please.
Thank you.
In which we made clear that there was no period in August when all of our witnesses were available. So, madam, again, we were flexible, but regrettably the defendants haven't been. And madam, I take you to that because really the upshot is as follows. Firstly, we are the ones who have been trying to move this case forward at every stage. We remain willing and able to start this trial on the 31st of May. That is the date that the parties had agreed. And if the defendants want to get this case on as quickly as possible, then we say no reason subject to the court's availability as to why it can't come on the 31st of May with directions to that end given today. But madam, secondly, we are trying to be flexible. The defendants, not us, clearly want to push the trial date back. And we have made clear that we do not object to that in principle. But as will be obvious to the court, that has to be at a time when our witnesses are available. And they are not available in August. And madam, can I just explain in relation to that what the issues are? James Potter is unavailable until the 11th of August. Madam, you may or may not have picked this up, but he was the head of the area of the business in which Mr. Olayanju worked for a substantial period of time, including the time that Mr. Olayanju says that there was a repudiatory breach of his contract.
Understood. And how many witnesses do you intend on calling, Mr. Craig?
Madam, I think we've lost Mr. Craig again. Let me just see if I can reach him.
Okay, thank you.
Madam, Mr. Craig's just about to dial back in from another phone, so fingers crossed that works.
Thank you very much, Ms. Rogers. Yeah, this is quite unusual because we've had many hearings, and I've personally had about 4 or 5 hearings remotely. One of them was even, I think, almost up to a full day, and we didn't have any issues with the connector, so I think we must just be experiencing very bad luck today.
Madam, I'm terribly sorry about the
no
issue.
problem at all, Mr. Craig.
I'm joining now from a mobile, so I'm hoping that is going to be more effective.
Good. Fingers crossed. Thank you, Mr. Craig.
So,
I was asking how many witnesses you intended on calling, just as you were introducing James Potter.
Yes, at the moment, we're anticipating calling 4.
4, good.
But we have difficulties with 3. So the first was, Mr. Potter. You'll appreciate he's clearly an important witness given the allegations that Mr. Olayanju made. Madam, I should say that 4, that's to be confirmed once we have the responses to the Part 19 request. It may be that there will be others. Madam, Andy Berry took over from Mr. Potter before Mr. Olayanju resigned. He was involved in some of the key discussions with Mr. Olayanju. He was the individual who gave a witness statement on behalf of the claimant of the interim relief application. So again, an important witness. He is unavailable for the last 2 weeks of August. And another of our witnesses who dealt with Mr. Olayanju's grievance, which forms the subject matter of his repudiatory breach claim, Anna King, is unavailable from the 7th to the 23rd of August, and then again from the 28th to the 31st of August. So as we have repeatedly made clear, our witnesses are not available in August, and at the risk of stating the obvious, the trial can't probably go ahead without our witnesses. That would be grossly unfair.
Mm-hmm.
We have suggested that we can accommodate their request to put the trial back until September for a matter of 4 weeks or so from the date that they're suggesting. There's no material prejudice to the defendant in that, but they point blank refuse. And I'm afraid to say that is frankly consistent with what has been an obstructive approach to this litigation so far. And Madam, I'm sure I need not remind you of the overriding objective that the parties
are required to help the courts further the overriding objective under Part 1.8 of the DIFC Court Rules, which of course includes ensuring that the parties are on an equal footing and dealing with cases expeditiously and fairly. Madam, the parties clearly would not be on an equal footing, and it would not be fair if this case was listed at a time that my clients witnesses are unavailable. As we say, we are content that the court list this matter on the 31st of May, as previously agreed. Or we could start on Sunday the 6th of September and, if necessary, interpose Ms. King's evidence into the defendant's evidence. But if the defendants really do want a start date later than the 31st of May, it's remarkable that they just don't agree to that. And Madam, I should also say the defendants have indicated that they intend to refer the court to 3 authorities. They haven't explained why, but if their point is that proceedings such as these should come on expeditiously, we agree. We are the ones who have been trying to move this case forward, and we are the ones who are ready and willing for this trial to start on the 31st of May. It's the defendants who want to delay the start of the trial. And all we're saying in relation to that is we are prepared to accommodate that. We are prepared for it to be pushed back beyond the 31st of May. But to the time or to a time when our witnesses are actually available. Mm-hmm. And frankly, it's highly regrettable that the defendant simply didn't agree that. And then the other point, of course, we've made is that the defendant, or the second defendant, has the benefit of a cross-undertaking in damages. And you'll see that at page 158 of the bundle.
What page, sorry, Mr. Craig? 158?
158.
158, thank you. Yes, the usual undertaking with respect to freezing orders and injunctions. Yes, thank you.
Yeah, exactly so. The second defendant, one of the points that's made is, well, Mr. Olayanju is not being paid. Well, the difference between August and September is difficult to understand why that makes such an enormous difference. But in any event, he's protected under a cross-undertaking. So, Madam Magistrate, our position is either let's get this on the previously agreed date, 31st of May, with direction to that end now, or if the court takes the view that this should be pushed back because it's not convenient to the defendants for some reason, that it's then pushed back to September rather than August, because it's a simple point that we just don't have witness availability at all.
Understood. Thank you, Mr. Craig. Mr. Craig, was that it?
Yes, unless there's anything, I mean, that's the principal issue. Directions will obviously flow from the determination on trial date. So unless there's anything in particular you want to hear from me in relation to trial date, those my submissions on trial date.
I was going to ask about the list of issues, but perhaps let's start with the trial date, and then we can work backwards from that. Ms. Ahmed, yeah. I am very, very curious to hear why 31 May is no longer a suitable date, considering that it was the very date that you had proposed and put forward to the claimant. So we'll hear from you, please, and then we can make some decisions after that. Thank you.
Thank you, Madam Registrar. And clearly the picture that's now being painted by my learned friend is that we have been inflexible and obstructive, and that's simply not correct. And it is a mischaracterization of the situation and the background and the correspondence, in fact. In terms of the defendant's position, there are a number of concurrent issues at play here that the defendants have been trying to balance in the most efficient and in the most pragmatic way. And that is taking into account the fact that these issues should not affect the administration of justice, nor should there be any prejudice to the parties. And it's in light of this balancing exercise that we've had to reconsider the timetable at various junctures in these proceedings. Before I go to explain the correspondence, if I can just perhaps set out the number of issues that we've had to balance and the issues that are to play here. And we say there are three critical issues. Now, the first issue is and was the issue of jurisdiction and the defendant's right to appeal the order that was made by His Excellency Justice Ali Madani on the 16th of April 2020. Now, my learned friend seeks to revisit events prior to the date of the injunction hearing, which was on the 2nd of March. However, we say that there is and there was a real live issue of jurisdiction. It is still a live issue subject to the right of appeal expiring, which is on the 6th of May. And therefore, Madam Deputy Registrar, in that context, it was important to weigh up the impact of any such appeal on the directions. And if I can just give an example, if the defendant appeals before the 6th of May, and if we ask for an urgent appeal hearing, then clearly the directions would have to be stayed and clearly they would have to be revisited pending the determination of the appeal. And therefore that was one issue that was in the balance. The second issue, which we considered would potentially have an impact on the trial timetable, and which does require some thought, and which was an issue that we will revisit in the course of my submissions, is COVID-19. Now, irrespective of the claimant's demonstrations, it's unrealistic, we say, to suggest that it doesn't have an impact on the timetable, and it's something that I will talk about when I take you to the letter that we wrote on the 8th of April. I have to say that since this case has commenced, neither I nor any member of the KBH team has had an opportunity to sit down with the defendant for a face-to-face discussion. It's not happened at any point in time since the commencement of the claim. And we say that's always a necessary part of any litigation and conducting litigation and in representing clients. And Madam Deputy Registrar, you'll appreciate that since the 5th of April there has been severe restrictions of movement, and the impact of this has been on the timetable that was agreed at that point for trial, and that's why the trial couldn't take place on the 31st of May, because the timetable to that trial was completely unworkable. Now, the third issue that the defendants had to balance was the impact of agreeing directions on the disclosure exercise. And we say that the timetable is dependent on disclosure taking place properly. And Madam Deputy Registrar, you'll appreciate that in any case, but in particular an employment case, especially ones which involve allegations of discrimination, the bulk of the documents will be in the employer's possession and control. And therefore we say that the disclosure exercise would have a significant impact on the case, and it has to be done properly, and it has to be factored into any timetable that is agreed. Now, unfortunately, to date, the claimants haven't taken this into account, and there has been some resistance to undertaking disclosure expeditiously or building time for disclosure applications. And if I can just add pause here for a second, if the defendants were being inflexible or obstructive, when the claimants made a suggestion that disclosure ought to take place in accordance with the civil procedure rules of the UK, rather than the rules of the DIFC court, we agreed to that because we thought that it would mean that disclosure could take place expeditiously. However, there still has to be some time in the timetable to accommodate the disclosure exercise, and there was some resistance on the part of the claimants to that. And therefore, Madam Deputy Registrar, it was taken into account all of these three factors as enumerated and as just stated that led to the letter of the 8th of April, which you've already seen, which I will take you to, whereby it was suggested that the timetable is revisited. Madam Deputy Registrar, there is no doubt that the defendants have always wanted this case to be listed for a speedy trial. However, that has to be balanced by the expense of it not being properly prepared for trial, which, if it's not properly prepared, is likely to have significant and far-reaching consequences for the defendants. So therefore, we say that any timetable must take into account the proper administration of justice. And in that respect, we do refute the unfortunate characterisation of the claimants that we have been obstructive. And perhaps maybe if I can take you very quickly through some of the correspondence which would make out this point. Madam Deputy Registrar, I don't know if you have tab numbers or if you are working on page numbers. Hello?
Thank you. Yes. Thank you.
Yes, are you working on tab numbers or page numbers?
I'm working on page numbers, please.
Okay. Can I then take you to page 186? This was on
the email.
An email written by us on the 15th of March, whereby we suggested directions. This was after the 2nd of March hearing. We say in the second paragraph that whilst we are waiting for reasons, there's no reason not for the parties not to agree a speedy trial. And in the interim, we propose directions. And so we propose those directions there with a trial to take place in the first week of May. And that was our suggestion because it's something that we wanted on behalf of the defendants. Can I then take you to page 194?
Thank you.
This was a letter written by Eversheds on the 16th of March in response to our letter, whereby there was some agreement to the trial starting in the first week of May. If I can invite you, Madam Deputy Registrar, to turn to paragraph 2B. This is where the suggestion was made for disclosure to take place in accordance with the rules of the CPR. And you see the date there, the 9th of April 2020. It was tentatively agreed between the parties that disclosure would take place on the 9th of April, and that was standard disclosure in accordance with the CPR, where all documents are served, those that are in support of your case and those that are adverse to your case. And we agreed to this, and therefore, had we been inflexible or obstructive, then we would not have agreed to it. Because clearly the disclosure exercise or production in accordance with the RDC we considered would take longer. Can I then invite you to turn at page 196?
Thank you.
And then paragraph 2.1, there was an agreement in principle by us to a trial date starting on the 10th of May or in the window of 10th of May. But this was on condition that disclosure would be undertaken fully. As I said, there is a real concern on the defendants that we have all the disclosure available to us and documents available to us that are currently in the claimant's possession. 2.2 is KBH's agreement to adopt into civil procedure rules in relation to disclosure.
Just a quick question, Ms. Ahmed. When was the original injunction order issued? I know the reasons were issued on the 10th of March.
10th of March.
So this was after, right. So these suggestions were made after the original order was released?
Yes, on the 17th of March.
Okay. And then one quick flag, and I'm sorry to interrupt you, and we'll get back to submissions in 1 second. I believe the reasons were issued, the order with reasons was issued on the 12th of April, not the 16th of April.
But that was then amended on the 16th. It was amended on the 16th.
With regard to the cost paragraph. Right.
Yeah.
Okay. Okay, thank you. Please continue.
And so bearing in mind the extensive disclosure that will be required from the claimants, we wrote to the claimants in this letter, and if I could turn you to page 197, and at paragraph 4.1, we explain to the claimants that given the contracted timetable and taking into account the claimants' concerns about the concerns about building in time for any argument in relation to disclosure, we set out quite clearly our requests and our expectations in relation to disclosure, so that any disclosure or lack thereof would not have an impact on the timetable. And you can see pages 197, 198, 199, 200, 201 and 202 setting out the defendant's request for disclosure. And just, Madam Deputy Registrar, if I could ask you to turn to page 201 in that letter. We set out a request for specific disclosure there, whereby we request specific disclosure of documents, that again, it wouldn't hinder the ability to prepare for trial, given it was such a contracted timetable, and given we had agreed that trial would take place in the first week of May, or the second week of May. We asked for documents specifically at paragraph 4.2, and at page 203, this was the response that we received 6 days later from Evershed. And at paragraph 2C, Evershed's response was that they didn't want to build in time, or gave the impression that they didn't want to build in time for any application for specific disclosure, despite the fact that we had already requested that in our earlier letter, and that would depend upon the court's resources and the nature and scope of the application. Page 204, under the title Disclosure, and in respect of our specific production request, their response is set out there, which was, well, most of the documents are exhibited to Andrew Berry's witness statement, and in any event, we will confirm and search and disclose documents. To date, there has been no disclosure in response to this letter, to our letter that was written on the 17th of March, which we say, of course, impacts the timetable and hinders it.
Okay.
2 days later, we write back. And paragraph 1.1, we agree directions. However, we say at that stage that this is a tentative agreement and will be revisited, or we'd like it to be revisited in light of the evolving circumstances caused by COVID-19. That's at paragraph 1.1. And so even at that stage, and you'll recall the restrictions that were in place. Now, the restrictions weren't as severe as those in place on the 5th of April, because you will recall on the 5th of April, there was a 24-hour lockdown in Dubai. Mm-hmm. However, there were still restrictions in terms of social distancing, in terms of remote working, in terms of people in work and the percentage number of people at work. And therefore, we agreed these directions. However, we were concerned that this situation may evolve and it may impact and hinder our ability to be able to prepare for trial, given at that point we had no face-to-face meeting with our clients. And so we tentatively agree at 1.1. And 1.3, rather 2.3, we talk about disclosure again, because one of the responses that we had received from the claimants was that it was premature to conduct any searches for documents, given that there was no agreement in relation to proposed keywords. And so at paragraph 2.2 and 2.3, we say that in order to avoid unnecessary debate and not to waste time, we provide a list of keyword searches. We also explain at paragraph 3 that we don't have any copies, bar one, of the documents that we requested by way of specific disclosure in our letter of the 17th of March, and therefore please provide those documents. Again, there has been no provision of any documents either in response to the keyword searches or in response to our request for specific production. At page 209, yes, we see Evershed's particular response dealing with our request for disclosure, bearing in mind this is something that's going to be quite extensive and have far-reaching impact on the way that this trial is prepared.
I'm just having a quick read through the letter, Ms. Ahmed. Thank you. Thank you, Ms. Ahmed.
This was even though on in their letter of the 16th of March, the claimants accept that the burden of disclosure will fall on the claimant. If I can just take you back to that letter, my apologies, at page 195.
195, sorry?
Yeah, 194. The sentence starts at 194.
Yes, thank you.
This is when the proposal was being made in relation to whether or not disclosure should take place in accordance with a CPR or with RDC. The claimants accept that the burden of disclosure falls on the claimant. And it was with this in mind that we wanted to speed up disclosure, which is why we made our request very early on. Following this, and you've already been taken to this email, page 211, the claimants wrote to the court wanting to list the trial starting on Sunday the 10th of May. And at that point, that was the agreement of the parties, subject to disclosure taking place properly, subject to any evolving circumstances of COVID-19, and subject to the appeal in relation to the reasons provided by the court. In response, on the 30th of March, page 216, an email was written by the court stating that it wasn't going to list the trial until the parties had been furnished with the reasons of the urgent application. Now, my learned friend Mr. Craig said in his submission that, in fact, it was the claimants that wrote to KBH with a list of issues. That's not correct, because it was following on from this email on the 30th of March that, in fact, it was KBH that wrote to the claimants, and that letter is on the 30th of March. And my learned friend is not taking you to this paragraph, and that is the first paragraph that refers to the email of the 30th of March from the court. And suggests...
On what page is it, Ms. Ahmed? Sorry?
Page 164. 164.
164. Thank you.
Whereby we say that the email of the court suggests that we ought to await reasons. However, given at that point that we'd filed our respective statements of case, we set out the summary of pleadings, and then at paragraph 3, in fact, we took the initiative to draft the list of issues, and therefore it's unfair for Mr. Craig to say that it's the claimants that are trying to push these matters along. In fact, at that stage, we were trying to push matters along. In light of the court's email, we provided a list of issues, and in light of the list of issues, we tried to agree directions. And that's the paragraph at 4.3 that you have been taken to. And what we say is that we would suggest a date for listing pushed back to the first week of June to allow for a more realistic timetable. And that was because of the points that I have mentioned, namely the appeal that we were considering, or the defendants were considering, and the disclosure exercise, because at that point there was still some resistance by the claimants for disclosure. They hadn't disclosed any of the documents that we'd requested, and therefore it was anticipated that there may be some argument in relation to disclosure or the inadequacy of disclosure. And it was only following our draft list of issues that the claimants wrote back on at page 223 with a revised list of issues. Now, granted, questions were asked about the employment tribunal claim. However, Madam Deputy Registrar, we attached the Employment Tribunal claim to the defendant's defence and counterclaim, which had been served at that point. And bearing in mind that the claimant's legal team is not only based in Dubai, but they have a team in England. And therefore, it would have been obvious to the claimants that there was some backlog in processing the Employment Tribunal claim. And therefore, whilst those questions were asked, the answers to those questions weren't outside the bounds of what the claimant's lawyers, the London lawyers, would have known in relation to that Employment Tribunal claim. If I can then take you to page 225. This was a letter written on the 6th of April 2020. And you've already been taken to this letter. But what arises out of this letter is the extensive requests made for disclosure by the claimant. So paragraphs, or rather pages 225 to 227, deal with the disclosure that the claimants were expecting. Bearing in mind that disclosure had been tentatively agreed at that point for the 9th of April. And so in comparison to when KBH made its request for disclosure, which was on the 17th of March, this request was extensive, and it would have required a more extensive and more comprehensive search to meet the deadline of the 9th of April by which disclosure had been agreed. We then wrote on the 8th of April, at page 228, so bearing in mind the tentative date for disclosure was the 9th of April, we had made our request as early as the 17th of March, but we hadn't received anything. The claimant now makes its extensive request on the 6th of April, and lockdown restrictions were imposed on the 5th of April. So in light of all of that, and in light of the fact that the defendants were still considering their position in relation to an appeal, and given the fact that, that it was impossible to meet the 9th of April deadline, given the request that had been made on the 6th of April, we wrote on the 8th of April, and Madam, if you could just please take a moment to read that letter, whereby we explain the difficulties that the defendant's legal team faced today.
Ms. Ahmed, thank you very much for taking me through these. I think I'm satisfied that the 31st of May is not a feasible date in light of the correspondence that you've shown me, and in light of the COVID situation. If we now turn to... Yes, I'll let you finish if you wish. But I'm interested in hearing about the September date, because I understand that... as Mr. Craig highlighted, witnesses for the claimant are simply not available in August. And if there were to be a delay of 4 weeks, and that would also buy everyone a little bit more time in terms of the development of the COVID situation, and getting everyone, getting your ducks in a row ready for trial in September. I'm curious as to why your client is not agreeable to a short postponement of the trial date, given that they had had in mind beginning of August, and what Mr. Craig had suggested was beginning of September.
Well, if I can just perhaps address you on that, but there has been some criticism of us as to the defendant's team being inflexible, and that's not the case. But dealing with your question, the reason why the August date was first proposed is taking into account all of the issues that I've outlined, and in response to a request by the court to try and agree dates, directions were sent to the claimant, wherein time was taken to consider the dates that would be workable for directions, and that is the directions that you have before you, and having complied with all the directions, or the parties complying with all the directions, the first date reasonably practicable was the first week of August. And that's why we proposed that date. Now, in terms of the date proposed by the claimants in September, the first time we hear about the proposal for a date in September was when the claimants wrote to the court stating, or rather wrote to us, and if I can just take a moment to find that.
Absolutely. And to respond to your comments earlier, I'm satisfied that you were not being inflexible and that you had reason for moving the dates around. So I'm not about to make a cost order against the defendants for being inflexible.
I appreciate
yes,
that.
I'll let you
let me then deal
with
with
correspondence. Thank you.
Of course, let me deal with then the question that you've raised. The first time when we heard about pushing the trial out to September was on the 23rd of April, and the email is at page 263. And what was suggested that the trial date couldn't take place in August because of witness and counsel availability. Now, Madam Registrar, ordinarily, if this was a CMC pursuant to RDC 26, parties would be required to file a case information sheet, and a representation of that is found in the rules, and it's Schedule A to the rules. And you'll be familiar with this, as no doubt the claimants to buy counsel will be familiar. But one of the questions that are being asked in the case information sheet is the number of evidence of fact that a party intends to rely on, and who those witnesses are, the identity of those witnesses. However, when the claimants responded to a suggestion that the trial ought to take place in August, they provided no information as to the identity of those witnesses. They provided no information in relation to the extent of their evidence and, in fact, the number of witnesses. And they only provided a very blunt statement, and therefore the defendants have no visibility as to the identity or the availability. And this is particularly important and critical when it comes to listing how long the trial will take place. And therefore, it's only the first time today that we've heard of the number of witnesses and who those are, and the reason why it's been suggested that they are not available. And I mean, the next email that was written was at page 276. And in their email at 263, where they'd said it was counsel and the witness availability, at 276, it wasn't then counsel's availability, but primarily to accommodate witness availability. Again, there was no explanation as to who the witnesses were, the identity of those witnesses, why were they not available, even though this is a fundamental step, we say, in trying to list a trial. And the information that the court requires ordinarily to list a trial as set out in the case management information sheet. And even though it's the first time today that we've heard from Mr. Craig as to what the availability issues are, it's still not clear, given, and again I say this, given the COVID-19 situation, because travel is going to be difficult. So we don't know whether or not they are travelling outside of the country, or whether or not travel is involved, and what those commitments are. There is also no indication as to why, if the trial takes place by video link, why the witnesses can't be interposed from wherever they are, if they are still in the country and if they don't have any pre-booked holidays. We have no visibility in relation to the availability of counsel, or whether or not it's now being still suggested that counsel's availability is also an issue. And therefore, in the absence of all of this evidence, it's difficult for the parties to have a meaningful discussion about listing the trial, whether in September. And whilst the point has been made that this is only a short period of time, we say that it has significant hardship on the second defendant, Mr. Olayanju, because he's not working, he's no income in Dubai, which is a very expensive place to live, and therefore it causes him considerable hardship if this matter isn't decided, and if he has the ability to work, or he has no access to a salary which would for his living expenses. And so that's why we say that the first week of August is the first reasonably practicable date after which the parties have complied with the directions, that the trial ought to be listed, particularly because of the opaqueness of the claimant's submissions as to availability. And in terms of the injunction that was granted, Mr. Olayanju has this over his head, and I think I've already made the point that it is causing him considerable hardship. These are extremely difficult circumstances, and therefore what we are asking the court to do is balance the administration of justice, namely a workable timetable that parties can comply with in light of the various factors that are at interplay here, but also have in mind the significant prejudice caused to Mr. Olayanju of not having his case dealt with quickly, or that if it's put off any longer than is necessary because of the claimant's unsubstantiated contention that there is an issue with witness availability. I mean, the only thing that you've heard today is that the witnesses are not available, but you haven't heard the reasons why, and you haven't heard the full extent of who those witnesses are. And therefore, we consider, or really our position is, that it's simply unfair to Mr. Olayanju because it will cause him considerable hardship in circumstances where he is enduring hardship. And
I believe that Mr. Craig's submission, Ms. Ahmed, was that there was two definite witnesses, perhaps, and the other two or more witnesses might be revealed through the document disclosure process. But I'm interested in hearing your submissions in respect of the undertakings provided by the claimant, and Mr. Craig pointed us to page 158 of the bundle. And given that the claimant has made, yes.
No, sorry, my apologies.
Given that the claimant has undertaken to continue to pay the second defendant's salary and other benefits pursuant to the employment contract, how would a 4-week delay to the trial date affect your client? Given that there is quite a number of months and weeks between the initial date proposed being the beginning of May until the beginning of August. So I'm just interested in hearing a bit more from you on that.
Yes, of course, madam. At the moment, Mr. Olayanju is not getting paid a salary. He's not getting paid a salary from TPI or from GMG. In terms of the cross undertakings, those will only be decided once the trial of this matter is determined. At the moment, he still has expenses, so he's still got his rent to pay, and there's been no reprieve from the landlords in relation to that rent. And you'll appreciate that there can be very serious implications involved with not paying rent in this jurisdiction. He also has his living expenses, and Dubai is not cheap, and it's a very expensive place. And therefore, whilst the cross undertakings may take effect after the trial, there's real hardship to Mr. Olayanju today in trying to meet his living expenses in Dubai. And therefore, there is significant hardship today, and the cross undertakings don't assist him today, and nor have they assisted him since the injunction was granted.
Okay. Thank you.
And so, whilst it may appear that 4 weeks isn't a significantly long time, for Mr. Olayanju it is, because it could be the difference of him not being able to meet expenses and not having a flexible landlord who he can negotiate with. And as I understand, Mr. Olayanju has made cheque payments, which may potentially, which there may be an issue with. And therefore, Mr. Olayanju wants to avoid any issues that may arise with his inability to meet payments. And rent payments in particular.
Thank you, Ms. Ahmed. Do you have any further submissions on the point of the trial date?
I beg your pardon?
Did you have any further submissions on the question of the trial date?
No, those are my submissions on the trial date, but I would also like to address you on costs at the end of the hearing, if I may.
That's no problem. We'll let Mr. Craig reply if he wishes to the submissions raised by you, and then we can discuss some ways forward, and then we can discuss costs as well at the end.
Well, Madam, I'm entirely in your hands if there's any point in particular that you want to hear me on. Obviously, we've heard your effective ruling that 31st of May isn't practicable. So, yes. Madam, in the light of that, I don't particularly push against that, although you'll obviously have our submission in relation to that. And then if there is to be a delay because the defendants say that they can't meet the 31st of May trial date that had been agreed, Madam, you've heard my submission. Just maybe a few observations. First, in relation to cost, although I was making reference to the obstructive approach that's been taken by the defendants, just to be clear, I wasn't going to make an application for cost. I was simply going to suggest that cost be in the case. I was taking you to the obstructive approach simply in relation to the trial date. Second small point, that the defendants, Ms. Ahmed says that they didn't hear about our difficulties with the August date until the 23rd of April. Sorry, the 23rd of April. Two things. First, it was only at 9:30 on the 21st of April that they had suggested August. And as you know, the court had requested the parties to tell them what the position was by 10 a.m. on the 23rd, which is what we did. We made clear that we had difficulties with witness availability, since which time there has never been a question asked by the defendant of us as to what those difficulties were, who we were intending to call. And as I've said, at the moment, we still don't know who our witnesses are going to be finally, because we haven't had a response to our request for further information. And Madam, as to those witnesses we do know about, they have booked holiday. So as far as I'm aware, I'll be corrected about that if I'm wrong, I'm sure, by my solicitors. But quite where or how that will take place obviously is uncertain. It may be that they can simply stay at home on holiday, which they'd be entitled to do. They are entitled to take time off work. It may be they're going to be going away in this country. It may be they'll be going abroad if they can. But as I say, we are perfectly happy to accommodate a delay to the trial, but we simply ask that it be delayed to a date when our witnesses are available. And frankly, we don't think that should be terribly problematic.
Good. All right. Thank you very much, Mr. Craig. I don't think we're entitled to go and ask the witnesses to move their holidays, because the people who aren't quite involved in these proceedings, and every man is entitled to a holiday, particularly in the month of August, which is when lots of people in Europe tend to take time off. On that basis, I think it would be prudent to perhaps list the trial for September. That's when everyone will be available, and any damage or any harm caused to the defendant can be dealt with pursuant to the undertaking at a later stage, if there is anything that needs to be dealt with. I suggest that the exact dates in September be exchanged in amongst the parties, so that the parties then revert to the court with an agreed date for the 3-day trial by next Thursday, the 7th of May, 4 p.m. So if the parties please revert to the court with some agreed dates or an agreed date in September, and we can then list the trial for that date. Now, that is subject to change in the event that the defendant or one of the defendants files an appeal and their permission application succeeds, and then the case goes to appeal. Because at the moment we are having some slight difficulties with Court of Appeal listings, given the COVID situation. So I suspect what might happen is we might issue directions to stay the Court of First Instance proceedings until the appeal proceedings are heard, and that's when the question of jurisdiction will be put to the Court of Appeal in the event that the defendant or one of them files an application to appeal.
Madam, I didn't catch the date. My apologies, I didn't catch the date that you stated to provide the revised direction.
By the 7th of May, please, if the parties can agree on a date by the 7th of May, and if one of the parties can then email those agreed dates in September to the registry by 4 p.m. on the 7th of May.
Grateful, thank you for that.
In terms of the request for information, yes.
Mm-hmm.
Go ahead, Ms. Ahmed.
I was also, apologies, but you said that there might be some issue with the Court of Appeal listing. When is the earliest that the court considers that they could list an appeal?
The Court of Appeal is due to sit at the beginning of June. So if an appeal is filed by your client and if permission is granted, then we would hope that by June the court would sit. And that's taking into account that there might be some flights, or at least we might be able to get 1 or 2 judges flown in. If we can't, the court is currently looking at conferencing in 3 judges from different countries. We haven't done it before. We don't think it's impossible. I know in light of the call that we've had today, we don't seem to be too technologically advanced, but we're looking into dialing in judges from 3 different countries. And if we can do that, then the June sitting will go ahead. If we cannot do that, and if it means that the judges have to fly in, then we have to wait until the borders are open again. I suspect it will be the former, but I just wanted to alert you just in case the Court of Appeal did not sit in June. I just wanted to put that on your radar. But there should be nothing preventing you from preparing your case in the CFI case in any event, or at least doing some preliminary preparations in the event that the question of jurisdiction is determined in favour of the DIC court.
Great, well, thank you.
So 7th of May, in terms of the request for information and document disclosure, I'll leave that to the parties to decide on dates. And if the parties feel that further directions are required, you may write to the court. But perhaps, Ms. Ahmed, the request for information can be responded to as soon as you can, and document disclosure or document production can be exchanged as soon as possible so we can get the process going. Again, these directions might be subject to change in the event that one or more of the defendants files an application for permission to appeal.
Madam, sorry if I'm cutting across you. Just in relation to directions, it would obviously be helpful for us to have a response to the request for further information that we served on the 7th of April before we come back to the court with dates for a trial in September, because we need
Absolutely.
to know whether there is any other witness that we might need to call to address any matter that's referred to in the further information. Now, the defendants originally said that they were going to provide a response by yesterday, and so we would invite you to make a direction that that further information is now provided, say by the 3rd of May, in order that we understand what the position is and can take instructions before we have to come back to the court by 4 p.m. on the 7th.
I think that's sensible. Mr. Ahmed, is it doable to respond by the 3rd of May?
Madam Registrar, I'm still in the process of taking instructions, and it has been difficult. So obviously we can write to the claimants. We understand it's in everybody's interest that we respond to that. And if we can perhaps have an opportunity to write to the claimants to agree a date by which we can file that would be helpful.
Okay, why don't we do this? Why don't we move the agreed date for trial to the 14th of May? That will then give you, Ms. Ahmed, 2 weeks to seek instructions from your client and respond to the RFI.
Sorry, to agree the directions to the 14th of May.
So agree the date for trial by the 14th of May. And let's just say that you would then have less than 2 weeks because you need to get back to the Claimants Council on the RFI. So perhaps on Tuesday the 12th of May, which gives you just short of 2 weeks, to respond to the claimant on their request for information.
Great. Well,
so that's over 12 days away.
Yeah.
Mr. Craig, is that satisfactory?
Madam, if I could prevail upon you just to perhaps shorten that a little, because that only really gives us 1 day to find out what's going on with witnesses before we report back, or 2 days. It might be helpful if that could be brought back by day, say to the 11th.
Absolutely, yes. I think that makes sense. Sorry. And I thought I had the Monday there, but it was the Tuesday. So, Ms. Ahmed, I apologise. So, Monday, the 11th of May, which is still 12 days from today. And then that would give the Claimants Council some time to go through the information provided and revert with dates for the trial, and perhaps also consult witnesses on their availability for the trial before the 14th of May.
Understood.
Madam, can I also then suggest that the parties liaise in relation to the other directions in relation to disclosure, exchange of witness statements and trial bundles, because realistically there could quite sensibly be a sort of a 2 week change to some of those dates, but it's probably easiest if the parties just liaise about that. And if there's any difficulty, perhaps we can come back to the court in writing again by the 14th of May.
I think that's prudent. What I would love to see on the 14th of May is a draft order produced by the parties for the exchange of documents, witness statements, evidence, etc. So perhaps, you know what, I'm going to indulge you and even extend this a little bit more. How about on the 17th, you come back with an agreed trial date and agreed case management directions moving forward on the exchange of evidence, etc. And then we can seal that for you. And if there's any problems, you can contact the court and we can intervene again. But I suspect that we'll hopefully reach an agreement by then. Thank you. Can I just ask one thing? I noticed in the draft directions submitted by KBH that the skeleton arguments and written opening statements would be exchanged 2 days before the trial. We're currently changing that process a little bit because many of our judges are located overseas. And with the difference in time, etc., where lots of judges, for example, are in Australia, they're not seeing these submissions until very, very close to the trial. So could I please suggest that when you discuss the exchange of skeleton arguments that you provide 4 clear days instead of the 2 clear days?
Yes.
Thank you. Unless there's anything else. And then the question of costs. Ms. Ahmed, I did say I would hear from you on costs, but I'll tell you what I'm thinking at the moment, which is that costs in case management conferences and directions hearings are usually costs in the case. If you would like to make submissions, you're invited to, but I'm relatively set on it being costs in the case. But feel free to speak up if you wish.
Of course, madam. Well, this isn't a full CMC. The documents that are usually provided for a CMC have not been provided in this case. This is, and it was set down for a directions hearing. And it was a simple and straightforward directions hearing whereby the real issue was between the parties whether or not the trial date ought to take place in August or September. And that was something that was repeatedly said by us. But what we saw was that the claimants have used or tried to attempt to use this hearing to ventilate matters that were not really an issue. And therefore we say that there ought to be no order as to costs The claimants put forward a bundle of nearly over 300 pages. A fraction of that has been used. A short correspondence clip could have sufficed. They've also tried to introduce a statement of cost and tried to introduce an argument about whether or not costs for the injunction hearing should be something that should be deliberated and discussed at the hearing. This generated unnecessary inter-parties correspondence because the claimants were trying to argue a point that had already been determined by the judge. And not only did it generate unnecessary inter-parties correspondence, but it also generated unnecessary correspondence with the court, to the point that regrettably the court had to intervene and give a direction to the scope and nature of this hearing. However, despite that, the claimants still produced a note dealing with costs when it was obviously unnecessary. We have today at the hearing in attendance 2 senior barristers. Mr. Craig is a QC, and Ms. Amy Rogers, who's junior, is 12 years core. We have a partner, a senior associate, and Ms. Hineidi O'Connell, whose designation I'm not sure of. And therefore, these costs are all unnecessary. They're disproportionate. They're not proportionate to the type of hearing this was supposed to be, or the issue that was for discussion, which was namely whether or not the trial should take place in August or September. And therefore, we say that the only reasonable order to make in these circumstances, bearing in mind the conduct of the claimant, that there should be no order as to cost. And hopefully this will act as a deterrent to the parties not to run up unnecessary or disproportionate costs. And therefore, whilst I hear you, Madam Deputy Registrar, as to the order that you would like to make, I would like you to reconsider that order in light of the submissions that I've just made.
Thank you for the submissions, Ms. Ahmed. I have no doubt that in the event the detailed assessment takes place, it will be before me because I'm the one who usually takes on detailed assessment. But I hope that it won't come to that and the parties will agree on costs beforehand. So if it comes to a detailed assessment, then I invite you to reopen those submissions again at the detailed cost assessment. But at this stage, I would like to order the costing in the case.
Grateful. Thank you.
Thank you very much. Is there anything further?
Madam, just one thing in relation to cost. One idea that we did raise in our note in relation to the cost of the interim relief application, accepting that that's a matter that's going to have to be dealt with by the trial judge, is whether that's a matter that can be dealt with on the papers before we get to trial. We're obviously in your hands in relation to that. If it is, then we'd invite the court to deal with that sooner rather than later. But if the position is that that's going to have to wait until after the trial in September, then so be it. But we just wanted to raise that in case there was a way of addressing the interim relief costs issue sooner rather than later.
Thank you, Mr. Craig. Now, the trial judge will not be the same judge that was assigned the case initially, and the judge who granted the injunction. And I suspect that it was a very deliberate order that the injunction judge made, in that the costs were reserved for the trial judge, who is still, we still don't know who that judge is because it depends on when the parties are available. We'd have to look at the docketing system and when the judges would be available in turn.
Yeah.
So on that basis, I suspect that it was very deliberate that paragraph 6 of the order of the injunction is that the costs will be determined at trial by the trial judge. And I very much suspect then that if it's not an immediate order for costs, that the judge will direct the parties to try and agree costs amongst themselves, or otherwise then the claimant or whoever wins the case can then apply for a notice of commencement of assessment.
Yeah, understood. All right, that's very
But
helpful.
hopefully we won't get to that. Fantastic. Ms. Ahmed, is that all from you as well?
It is, yes. Thank you for your time, Madam Deputy Registrar.
Thank you, Mr. Craig, Ms. Ahmed. Thank you, everyone.
Thank you.
The registry will revert with those directions that I gave out later today in respect of the dates that we discussed. Thank you very much.
Thank you.
Thank you.
Thank you. Bye-bye.
Good morning.